This is a convening of the Massachusetts Gaming Commission. Today is July 1st, 2025. It's approximately 10:04 a.m. I'm Jordan Maynard. I'm serving as the chair of the commission, and we are holding this meeting virtually, so we will do a roll call. Good morning, Commissioner O'Brien.
Good morning, I'm here.
Good morning, Commissioner Hill.
Good morning, I'm here.
Good morning, Commissioner Skinner.
Good morning.
And good morning, Commissioner Broder.
Good morning.
All right, and it's meeting number 557. With that, I believe we're going to turn it over to Secretary Skinner, who has 4 sets of minutes with various dates. It was going back in time, Secretary.
Yep. A little ways back. Well, not quite. They just about a little over a year ago. We've seen older ones come through recently, so that's my measure. Okay, Mr. Chairman, I move that the commission approve the minutes from the February 21st, 2024 and the March 21st, 2024 meetings that are included in our packet, subject to any necessary corrections for typographical errors or other non-material matters. Second.
Thank you. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Abstain?
And I vote yes, 4 and 1 abstention.
I further move that the commission approve the minutes from the May 22nd, 2025 and the May 27th, 2025 meetings that are included in our packet, subject to any necessary corrections for typographical errors or other non-material matters.
If we could separate those, I wasn't at the 27th.
Oh, I apologize. I just looked up too. All right, let me separate the 2025 meetings, starting with May 22nd. So I withdraw my motion.
That's okay.
And I move that the commission approve the minutes from the May 22nd, 2025 meeting that are included in our packet, subject to any necessary corrections for typographical errors or other non-material matters.
Second.
Thank you. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes, 5-0.
And finally, I move that the commission approve the minutes from the May 27th, 2025 meeting that are included in our packet, subject to any necessary corrections for typographical errors or other non-material matters.
Second.
Thank you. Commissioner O'Brien.
Abstain.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes, 4 and 1 abstention. All right. Congratulations, Secretary Skinner, on a wonderful year of doing a lot of this work. And thank you to the legal team, Judy, and all the folks over there. And I feel sorry for the next secretary.
Well, you can hold that until the next meeting. You can
She's
hold
got
that
one
till
more
the
to
next
go.
meeting. Yeah, I've got one more. And Jenna and I realized that because technically the changeover is not until July 15th. So you got one more meeting with me as secretary chair.
Well, I can tell you, I'll thank you in advance because I know it's coming up soon and there won't be too much more to do before you turn that gavel over. All right. With that, Commissioner Hill, do we have anything on the legislative front?
We do, Mr. Chairman. As you probably saw through emails from Grace and from Derek, the budget was passed by the House and the Senate. The conference reports were filed on Sunday, and yesterday they were voted on, and they were sent to the governor's desk for her to be able to go over it. And as we all know, the governor has 10 days to veto parts or whole sections of the bill. So within the next 10 days, we may see some changes, but in regards to those things that we are aware of that affect the Mass Gaming Commission, I don't see any changes taking place in regards to the governor doing any vetoing. But here's a summary of things that the 3 big issues that we cared about. And one of them actually was a little bit of a surprise to us, which was the line item appropriation 1050-0140, which is payments to cities and towns hosting racing facilities. So this would be Boston, Revere, Raynham, and Plainville. The House originally had funded this line item at $922,000. The Senate, however, chose to zero it out. And through the negotiations of the conference committee, in the end, the line item was zeroed out. So the payments to the cities that I mentioned won't be seeing these dollars as they were eliminated in this year's budget. Outside section 13, this was an issue that we've been working on as a commission for a couple of years now. Outside section 13 of the budget has the proposed language aligning 23N with 23K around the disclosure of publicly sensitive information. This was something that we had asked for, and we had worked with the House and the Senate leaders to get this language, instituted somehow in some vehicle, and they chose to do it in the budget. I would be remiss if I didn't thank, the staff, Grace and Derek and former GC Grossman and others for their hard work getting this through. A lot of meetings took place and a lot of explanation was needed, to new staffers up in the Hill about what we were trying to do. So we're very grateful and thankful that this language made it through and is now sitting on the governor's desk. And then outside section 104 of the budget sets the distribution of revenues from the category 1 licensees for FY26 only, which was the case last year, meaning the distribution would revert back to 23K for FY 2027, unless modified again in next year's budget negotiation. And it does include 2.5% to the RHDF. It does not, however, as we expected, include a distribution to the Community Mitigation Fund. So as we had feared, no dollars will be going into that account again for FY26. The Attorney General's office was seeking a change to their enabling legislation to increase funding from the Mass Gaming Commission's Control Fund for enforcement action in the illegal gaming market. And currently the commission can only reimburse the AGO for $3 million for those efforts. The $3 million had been capped since 2011, and the legislative change was not adopted by the conference committee. So we'll continue to work with the AG's office on identifying alternative funding mechanisms moving forward into FY26. So with that said, that is my legislative update for today, Mr. Chairman.
Thank you, Commissioner Hill. It's a very substantive update. Want to thank you and all those who worked on these issues, and I want to thank the legislature for this hard work that they've done. And we have two members formerly of the General Court with us, luckily, here on the commission, and just want to thank those folks for getting this work done. And it was on the elevator news this morning as I was riding up that the bill had moved over to the governor and that it's on time, which was good too. So any comments, questions, commissioners? Thank you, Commissioner Hill. All right. We're now going to turn it over to item number 4. And for that, Executive Director Serpa, good morning.
Good morning, Chair Maynard. Thank you very much. I do have 2 updates for us today. And as we'll move forward, I guess we'll start with the first one involves some postings that I'm working on for the open positions of CIO and General Counsel. The materials for this discussion are in your packet, pages 47 to 58. I apologize for being a little slow in getting these postings ready, or at least the CIO posting. I have been focused on it and have finally brought it to the point where I think we can move forward on both positions. So today we're talking about the actual postings for General Counsel and Chief Information Officer. I need to point out that once these positions are filled, the people in them would be designated as major policymaking positions for the purposes of the Commonwealth's annual statement of financial interest. And so in our organization, this makes them subject to MGC hiring policy 10301. So as you know, per that policy, at the beginning of the hiring process, I am supposed to come before the commission to determine if the commission has a preference on its involvement in the hiring for that role. There is a list of all the positions for which hiring policy 10301 applies in your packet. And then there's also a copy of the policy in there. And specifically, as I know you all know, the policy states that the commission's level of involvement may include, but not be limited to, either A, the chair's designation of one or two commissioners to participate in the hiring process, or the commission simply receiving notification and or review of the job postings, or the implementation of certain notification requirements during the hiring process, or simply delegating the entire hiring process to the executive director and staff. So the purpose today is to have that conversation and to make sure I'll be able to move forward in the next week or so with the actual postings. So with that being said, I guess I would just turn it back to you, Mr. Chair.
Thank you, Edie
Or
Serpa.
questions, whatever.
Thank you, Edie Serpa. So 103.01, we've used this multiple times. So it looks like we have a threshold question, right? Of how do we want to approach these two positions? And we would break those two positions up. Unless we feel that commissioner involvement is not necessary, which has never happened since I've been here. I would say that if we do choose the commissioner involvement route, that I would want to designate myself on the GC role. And I would actually like Commissioner Broder to join me, given his background as a mayor and an attorney, and the person with the most longevity left on the commission. I think the GC position is arguably one of the most important positions. And then if we choose to do the same thing on the information officer, I would say we should open up the floor, and I would designate whoever wants to serve in that capacity. Also, extremely important position, given the nature of sports wagering and so forth. And so that's kind of my 2 cents on those two things, but I'll kick it to the commissioners to kind of give where they are. Commissioner Skinner?
Thank you, Chair. So out of the two, I certainly would have thrown my hat in the ring for the one of the commissioners assigned to the GC role, having served as GC for over 15 years in my capacity as a public servant. I did serve as one of the commissioners on the hiring committee for the HR division chief, and so I can defer to your suggestion. I'm not happy to do that, but I will do that. I think it works. I take no significant issue with that. I think the next best, if Commissioner O'Brien agrees, I think the next best recommendation here is to have she and I serve as the two commissioners on the hiring committee for the CIO position. Oh, I'm sorry, Commissioner Hill.
I'm devastated.
No, I don't know
I'm
what
devastated.
I was thinking. I have no idea what I was thinking. So that being said,
I need a drink of Coca-Cola right now.
No, I'm thinking because I'm happy to step aside because again, I did serve as one of the commissioners involved in the hiring of the HR division chief. So I'm happy to step aside.
I have had ample opportunity to be on these committees, so I have no problem with the recommendations made by Chairman Maynard and Commissioner Skinner moving forward on both of these positions. And I do think involvement with the commissioners, Dean, is appropriate. We've been doing it since I was first appointed, and I have seen no problems with the process that we've put forward, and the committees that have been put together, I think, have yielded us great employees. So with that said, no problem with the recommendations. And I'm not taking offense to anything, Nikisha, trust me.
Well, I want to apologize again. I have no idea where that came from, other than the fact that Eileen and I have been pretty much in lockstep as decision-making goes lately. And so there you go. Thank you.
I will point out a majority of the, number one is we're all usually in lockstep, is what I would say is the vast majority of our decisions are 5-0. Commissioner O'Brien, I saw the response, but we do have a vast majority. And Commissioner Broder giving him the opportunity to serve on one of these. Commissioner O'Brien.
Yeah, I mean, I have the shortest tenure left, so if the decision was to keep me out of it, I don't have a problem with that either. All four of you are going to be here long after I'm gone. So it's really up to what Commissioner Hill wants. If you would want to be on CIO, fine with me. But if, people are asking for my participation, I'm happy to do it with Commissioner Skinner.
We'll give you one last hurrah.
Knock wood, right? That this is it for the next couple of years.
All right. We all good, Commissioner Broder? Are you willing to accept?
Yeah, I'm happy to do whatever, whatever role works. Appreciate you, the opportunity to be sure. And I do think, that have not yet met the new HR person, but both the process and individual folks who have met with her seem excited. So I think that process worked out terrific. And so I'm glad we'll have an opportunity to weigh in. Though, Dean, you will obviously have a seat at the table, and then we'll do this thing.
I was going to say, thank you, Commissioner Broder. I was going to say, Commissioner Skinner, going back to, I'm sure Dean would love for all of us to do 4 or D or whatever it is, and just
or none.
Yeah. So that being said, I would use the authority under 103.01A to designate Commissioner O'Brien and Commissioner Skinner onto the Chief Information Officer committee. So that's how we'll do it. And Commissioner Hill, you'll get a breather after all that legislative update that you've been working on this year. And all right. Do you have what you need, ED Serpa, on that piece?
Yes, I all understood. I can move forward, and I would just say in response to Commissioner Hill, all of the committees I've sat on have been extraordinary, and it's actually kind of fun to be on a project with the commissioners where you go from beginning to end. We did 14 or 15 first round interviews for the human resources position, and sometimes we get a little punchy, and I think that's a good experience for an executive director to have with staff and commissioners. So looking forward to doing it 2 more times in the coming months. So yeah, thank you very much, Mr. Chair, and I'll move on from that. And for the rest of the executive update today, the second part, I'm actually going to turn it over to Director Monahan of the Investigations and Enforcement Bureau, our director there. And she, I believe, is going to give us a brief update from the 3 properties on the implementation of weapon detection systems. So, Director, if you're all set.
Thank you, ED Serpa. Yes, good morning. I'm here today to give you an update regarding the status of the weapons detection systems of the 3 Massachusetts casinos. And given that this issue is security related, I will keep my comments at a high level today. So as the Commission knows, 205 CMR 138.20 prohibits persons from possessing firearms within or upon the premises of a Massachusetts gaming establishment. I am now happy to report that as of the end of May, all 3 casinos have weapons detection systems operating 24/7 at each of the entrances to the gaming floor. The presence of weapons detection systems significantly enhances the safety of patrons and employees at the casinos. And in fact, we've had reports of casino patrons expressing their gratitude that the systems were installed. So on behalf of the IEB, I'd like to thank the Commission for your leadership in this matter. We wouldn't be in this position today without your direction and your support. I'd also like to thank the operators for their hard work and collaboration as we worked through the many steps to get to this point. And finally, I'd like to thank the members of the MGC, and in particular, the Gaming Agents Division and the Gaming Enforcement Unit. The staff played a critical role in implementing the systems, and they continue to work hand in hand with the operators to ensure that the systems are functioning as they need to on a day-to-day basis. So with that, I will thank you for your time and happy to take any questions.
Thank you, Director Monahan. Commissioner O'Brien.
Just a thank you also to IED. This is something that we've been working on basically probably since before I got here. So I'm really happy to see that it's going well and that they're seeing positive benefits to it as well. So thank you to everybody involved with that and to the licensees.
Thank you, Commissioner O'Brien. I will note same thing she just said. Thank you, Director Monahan. Thank you to all your predecessors and all the work they put into this also. And I can remember sitting up in the governor's office many years ago, hearing how this just was never going to happen. And now it's happened. And, you know, the patrons, keeping the patrons safe, that's our #1 goal at the Gaming Commission. So thank you so much. Technology evolved too, that helped. All right. Anything else, commissioners? Anything else, ED Serpa?
Nope, that's it for today, Mr. Chair.
All right, thank you. So for the next item, it is the succession of officer positions. I believe that we're going to have to potentially take some votes, and I may need some help walking through this, Councilor Stempick, just on which ones we do first and how we do them, and do people need to be formally nominated? I forget. I put this out of my head every year.
Yeah, I think Jenna is on the call and she's drafted the motion, so I think she can provide you with that counsel. So I think.
Perfect. Thank you. Hi, Jenna.
Thank you, Jenna.
Good morning, Chair and Commissioners. I'm happy to provide whatever assistance that you may need in this process.
All right. Do we want to start with the secretary position?
I didn't know if Commissioner Skinner wanted to do the honors to pass the baton.
Absolutely. Thank you. I'm looking right at you,
Love Commissioner Broder.
So I nominate. Are we nominating? Did that question get answered? Or
Yeah.
we're just
I think
moving?
you nominate through the motion, I believe, and then we.
Okay. All right. Well, so I, in accordance with MGL Chapter 23K, Section 3F, I move that the commission appoint Paul Broder as secretary for a term of 1 year.
Second.
Thank you. Any discussion?
This is when he
No,
Our
declines.
nomination's still open.
no discussion, no discussion at all.
We had a whole memo that dealt with it.
Mr. Chairman, I will take a moment to recognize the past service of or soon to be past service of Secretary Skinner. And on this august day, for those of you who don't know, this is Bobby Bonilla Day, which is a seminal event in sports world. It's an honor to be able to step forward on this particular day to potentially, I don't want to suggest that this vote is a foregone conclusion, Lord knows, but appreciate the potential confidence that my fellow commissioners will express.
That is well said, Commissioner
Fresh
Broder.
optimism of Commissioner Broder.
I agree with you, Commissioner Broder. Commissioner Skinner has done a fantastic job. The person that had it before her didn't do as well. That was me. And I will tell you that I think everybody at this point, once you step in, will have had an opportunity to serve in that role. And it takes a lot of work to diligently read those sets of minutes, but it does give you great exposure to our fantastic legal team. So thank you for stepping into that role if we so elect you. All right, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0. Congratulations, Commissioner Broder.
Mr. Chairman,
Commissioner Hill,
in accordance with MGL Chapter 23K, Section 3F, I move that the commission appoint Commissioner Skinner as treasurer for a term of 1 year.
Second.
thank you. Any discussion? Commissioner Skinner, thank you so much for stepping up into this role again. You've performed fantastically at it, and I know you work well with Derek and the team, and just look forward to working with you in that capacity again. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0. Congratulations, Commissioner Skinner, treasurer, and Secretary Broder, incoming Secretary Broder. And thank you again to Commissioner Hill for his service as treasurer. We know that's Commissioner O'Brien.
I was gonna say, that was 2 years ago.
Yeah, I'm off. Commissioner O'Brien for your past service, and then Commissioner Hill's past service also.
Adding a thanks, Chair, to Commissioner O'Brien and her service as treasurer. I hope that this next fiscal year goes as smoothly as this one that we're wrapping up now did. Fingers crossed.
Well, we try to be good stewards of the assessments here, and Commissioner O'Brien kept us on track on that. So thank you. All right. With that, we're going to turn it. Commissioners, I'm assuming we have nothing else on this item number 5. So then I'm going to turn it over to item number 6, which is Dr. Lightbound.
Mr. Chairman,
Commissioner Hill.
my fellow commissioners and staff have been very good to me over the last 3.5 years with my the fact that I need multiple meetings to understand stuff, whether it be a 2x2 or going in and talking to individual staff about issues that come before us. And this particular issue came before us a couple of weeks ago, number 6. And I have to be very honest with you, Mr. Chairman. I am still trying to understand the ramifications of what's being asked of us today. And I would really like to put this off till another meeting. However, I know that there's a lot of people who are here today, but I'm going to ask through you and to my fellow commissioners what process they would like to take right now, if they would allow me not to, let's not have this issue today, or should we start it and finish it another day? But I have to be honest, there's a lot of unanswered questions that I have that I don't think I'm ready to ask publicly in regards to this issue. And I'm sorry I'm throwing this out. I don't normally do that without giving you a heads up, Mr. Chairman. But the more I went through it this morning, the more questions I had than answers that I had.
Mr. Hill, there's it's I'm used to that. Don't worry. And by the way, I've been struggling with this and need the help of the full commission to figure this out too. Commissioner O'Brien?
Yeah, I'm fine, absolutely. And accommodating Commissioner Hill, I would suggest we start. I mean, his point that people are on, I think we start the conversation in the Q&A today, understanding full well, Commissioner Hill, that you are not in a position to vote. And I think there might be more than you who feel that way.
Yeah.
Thank you.
Commissioner Broder just raised his hand on the same, that looked like a retweet. Commissioner Skinner?
The same. Always happy to accommodate a fellow commissioner needing more time to fully digest an issue that's before us for a vote at that.
So if I
Thank
may, thank you, Commissioner Hill. If I may kind of package this up for Dr. Lightbound and our guests. When I was approached to add this issue, I said this could absolutely happen in my head, because I have a feeling the entire 5 of us feel the same, which is this escalated quickly, right? This came out of nowhere and then it escalated quickly. and it's involving all of our historic racetracks and the properties that are associated with those. And so I don't want to make any decision today myself, too, that is rushed. And so I think if we're able to hear out kind of the issues, talk about those in public, then potentially ask any questions, and then take it under advisement as a commission, get further briefed, and then make a decision at a later date. That's how I would want to go forward. And it sounded like the commission just said something similar. Yep, I'm getting some thumbs up and nods. So that's how I would approach this, Dr. Lightbound. And I'm sorry that I didn't give you a heads up that's kind of how we're going to do it. But I needed to wait to hear from the commission to see if we were all feeling the same, and it seems like we are.
Yes, that totally makes sense. I know that Justin and I have been struggling with different issues as well. And we've had Nina Pickering Cook from A&K look at it also. So it is a multifaceted discussion for sure.
And Chair, we're happy to at least frame some of the issues for the commission now, so that to the extent anyone has questions that they feel comfortable discussing. Now, I know we have a number of the stakeholders on the call, and you may want to hear from them or ask them any questions you feel ready to ask. That being said, we completely understand much of this material has come in basically from Friday afternoon until late yesterday. So Alex and I are still digesting some of this as well. But I can highlight a couple of the issues, and then if we can certainly give an opportunity for any of the stakeholders to say a piece or answer any questions commissioners feel comfortable asking. And so we can make some progress today is what I would suggest. And then we can continue on, and if additional questions come up, we can bring those up before the commission at a future meeting.
That works. Commissioner Hill, does that work for you? That works. So frame it up.
Okay, I'll frame it up. So this issue came up as a result of the Massasoit Greyhound Association, what we often refer to as RANM, coming before asking for to add a additional advanced deposit wagering provider, but in the name of Churchill Downs Technology. Churchill Downs had been a prior ADW provider to Suffolk. Churchill Downs is now switching to partner with RANM. Under our statutes and regulations, approval of ADW providers comes before the commission. And when we started to look at this issue, a couple interesting sort of legal questions came up, and we went back and posed some of those questions back to the stakeholders to get their perspectives, and we looked at it a little bit more closely as well in legal and with the assistance of outside counsel in Nina. And I think it really distills down to one particularly difficult sentence in the account wagering statute. So the account wagering statute is 128A section 5C. So that the simulcast statute is a different statute. That's 128C section 2 is the primary simulcast statute. So, and this is in the memo that's in the packet too. I can direct you to that as well. You can see the language I'm talking about. It's in the packet at page 59. So the first block quote there, the language that I think we're being sort of forced to sort of evaluate and interpret is in this 128A section 5C. It says each person's in relevant part, it says each person licensed to conduct a running horse, harness horse, or dog racing meeting may establish and maintain betting accounts with individuals for use in connection with account wagering on races offered by the licensee. And this is the critical phrase, as the licensee is otherwise authorized to accept in accordance with this chapter and chapter 128C. So chapter 128C is the simulcasting chapter. And the reason why that's important is because a simulcast chapter has certain limitations on when simulcast wagers may be taken based on time of day and the type of racing licensee. So like RANM has different limitations than Suffolk, which has different limitations than Plainville. So that raised the question, and we recognize that these limitations were put in place in the past to protect live racing interests, but they are still there. So the question that sort of came before us is the account wagering statute pulling in those limitations on simulcasting such that they should apply to account wagering? And that is what we have been sort of wrestling with, because there's no case law on this. There's no interpretation that anyone has previously been done. We're looking at this fresh, and this commission is looking at this as a fresh issue. So that, and we reached out to the various stakeholders. They've submitted written materials, which are included in the packet with their particular perspectives on this. And so we have a number of them here today, and I'm sure they'll be happy to share their opinions on this issue. But it's not a simple issue. It is complicated. The racing statutes are complicated. I'll note for the record as well that 128C, well, 128A, the account wagering statute was drafted nearly 10 years after the simulcast statute, so that plays in as well. So there's a lot of issues here. So I would suggest that we see how far we can get with conversation this morning, and then if there are further issues that you'd ask legal to look into, that you'd ask our stakeholders to look into, we are more than happy to do that. And I'll just tag Nina and see if there's anything she thinks I missed here in terms of laying the groundwork here, Nina.
No, not at all. I think, a lot of the sub issues we'll get into, and we can advise the commission on if they're brought up by the stakeholders.
So that's sort of the framing of the issue, Chair. And if there's any questions for me or for legal, I'm happy to address them now. Or if you want to turn to our stakeholders, hear from them, or folks have questions for other people, I'm happy to cede the floor.
Commissioners, do we have threshold questions for Justin? Or are we wanting to hear from our guests to see what their take is on what he just laid out? Hear from our guests?
I'd like to hear from our guests, please.
All right. Okay. Dr. Lightbound and Justin, whoever wants to go first.
We'll probably ask Raina to go first. I know Sue Rodriguez is on the call, and also Jed Nozel.
All right. So Attorney Nozel, hi, Sue.
Morning, Chair Maynard, Commissioners, Dr. Lightbound, and MGC staff. Just want you to know that joining me here is Bob Brooks, who's Vice President of Operations.
Morning.
Mike Mishno, who is our Chief of Security, and Andrew Silver from Twin Spires, the attorney for Twin Spires, is on with us. And I'd like to turn it over to our attorney representing Raynham, Attorney Jed Nozel.
Good morning, Chair. Good morning, members of the Commission. Thank you. First to start with, on behalf of Massasoit Greyhound Association, to the extent that the Commission needs additional time, we certainly want to work with staff and you, Chair, and members of the Commission to make sure your questions are answered. And we're certainly not looking to, push a vote that you might not be prepared to make at this time. I do want to introduce also Andrew Silver. I think Sue mentioned he is here, and he serves as senior counsel for Twin Spires, has a tremendous amount of experience when it comes to these particular matters. And, I'd ask him to weigh in here a little bit as well. Let me just sort of, set the table here, and we appreciate sort of the legal division taking a look at this particular issue. You will not be surprised that MGA's position is that this actually is a fairly straightforward and clear issue, with certain types of transactions being governed by very different sections of the statute. And when we discussed that, and when Justin discussed it earlier, he did point out to you the governing statute here is really 128 section 5C that deals with account wagering. The section that's referred to as quote unquote having limitations is section 128C section 2. And we think it's very clear that there is a distinction between account wagering and what is covered in section 128C, section 2.2. And I think it's very important as you do review this, one piece that's not in Justin's memo is actually a pretty key definition. And actually, Attorney Stempick used it today when he said, when simulcasting wagers can be taken. Simulcasting wagers is a defined term in section 1. You need to look at that definition, and you also need to look at the definition of simulcast. There is nothing in section 5C of 128A that implies or suggests in any way that that particular section is in any way governed by what limits may exist for purposes of simulcasting. These are two separate types of transactions that entities that are racing meeting licensees are able to enter into. And I also want to point out something that's also very important for the commission to take into consideration. MGA is not here asking for something new. This is essentially a contract that is being taken from Suffolk that has existed for years and coming over to MGA. And none of these issues have been raised in the past. And in fact, there are existing agreements that the commission has approved consistently, including one for MGA in connection with its another product that it has, as well as other agreements for Suffolk. So while we're very happy to answer questions and offer clarity, certainly to this, we think the statute is clear. There's nothing in the commission's regulations that says anything different about this particular process. And these are very different transactions. One, an advanced deposit wagering, and then a second session that deals with limits on when simulcast can occur. They're different. We think it's a fairly clear, straightforward statutory interpretation here, and we certainly are happy to answer additional questions. And I would like to give Mr. Silver just an opportunity to weigh in here as well. Obviously, his experience here is important, and I think he has a particular perspective on it as well.
Thank you, Attorney Nozel, and thank you for your perspective. Mr. Silver, welcome to the Gaming Commission.
Thank you, Chair, and good morning, commissioners and staff. I'm very happy to have the opportunity to speak with you all. I'm sitting here in Louisville, Kentucky, but I'm a Massachusetts native, and it's my first opportunity to go before the commission. So I appreciate you all taking the time and consideration to this matter. And certainly very much appreciate the fact that the commissioners and staff may want to continue thinking this over. And to the extent any questions come up today that we can provide additional information on in writing, we'd be happy to do that in the coming days and weeks. But sitting here today, certainly happy to answer any questions. I think Mr. Nozel said a lot of what I wanted to go through very well, and I'm going to try to not retread too many things. But I think the overarching point that I might make is that I observed Mr. Stempick say something that this is a fresh issue. And I guess that's where, from a Churchill perspective, we entered into an agreement with MGA thinking that this was in no way controversial and not a fresh issue for the very reasons that Mr. Nozel alluded to. The fact that MGA has for, I think, decades had account wagering with Dial to Bet, which is operated by US Off Track, one of our peers in the advanced deposit wagering space. And the fact that Suffolk Downs, our historic partner, has had account wagering agreements, not just with ourselves, Churchill Downs Technology Initiatives Company. I may refer to us as Twin Spires or CDTIC, but also with several other peers of ours in the advanced deposit pari-mutuel wagering space. And I guess one other item missing that I didn't see in the memorandum from council. Certainly there are references in the statute to limitations on what the Greyhound race meeting licensing may be able to do as far as simulcast wagering it's our position, and I'll echo that of Attorney Nozel, that account wagering is something that is different and apart from simulcast wagering. But there are also limitations in subsection 5 of section 2 of chapter 128C on what horse meeting licensees can do as far as simulcasting. Horse meeting licensees cannot show or cannot simulcast harness racing meets while Plainridge is running live racing in Massachusetts. That's not a restriction to which Twin Spires and the other ADW operators in Massachusetts that have contracts with Suffolk Downs have historically been subjected to. And so again, in addition to my belief that the statute is clear on this, I believe there's a past practice and past precedent for account wagering exactly along the lines of what we're proposing to do under contract with MGA to proceed and go forward. And I guess I'll try to quiet down and answer any questions shortly. But I guess one other note that I'll make is that I noted a comment submitted by Plainridge Park, essentially taking the position that it is the only licensee in Massachusetts that can offer account wagering. We obviously disagree with that position, but again, we think that were the commission to adopt that position, that would not only call into question MGA's account wagering arrangements, but also the account wagering arrangements of the licensed horse meat licensee. So again, very happy to discuss and answer any additional questions from Mr. Chair or the commissioners or staff. We're also equally happy to take anything away and respond further in writing as you all consider this issue. But again, our belief was that this was relatively straightforward. We totally understand the questions, and we want to respond as best we can.
Thank you, Mr. Silver. I'll note that I'm originally from Pikeville, Kentucky, and I'm sitting in Boston, Massachusetts. So inverse trajectories for our lives. So let me ask a question, Justin, Dr. Lightbound. Do we have other folks that want to weigh in, and or do we need to start questioning now? How do we want to do that?
Alex, who else do you know who else is on the call as far as any stakeholders?
Yes, Paul Umbrello's on by phone, and Steve O'Toole is on also. And they submitted comments and are willing to speak.
All right, so commissioners, do we want to go ahead and ask, since I was just making sure that we've exhausted the folks from Rainham. Do we want to go ahead and ask any questions of them, or do we want to hear from the other folks?
Mr. Chairman, I'd like to hear from the other folks, and I'd like to hear from them, if there's any difference or opinion or rebuttal, because it seems like this is a kind of a dispute. If it's as straightforward as is being suggested, just certainly it seems like this is something the parties in interest should be able to work out, at the table, and then come back and tell us what the preferred resolution would be. That may not be possible, but that's what I'd like to see.
Yeah, Commissioner Broder, it's funny you're picking up my thinking too, which is, 3 weeks ago I was enjoying the first week of June, smiling, walking around the Arboretum in West Roxbury, having a great day, and I find out that we're blowing up this. I can only compare it seems like Mad Men, the show. Just out of nowhere, and we have all these moving parts. And to your point, Commissioner Broder, this is a small industry in Massachusetts, and we want to protect the entire industry. We want to protect those that have jobs in the industry, and we obviously want to be able to make sure the revenue is coming into the Commonwealth, which has always been anticipated. So a little disappointed that we're even here under these circumstances. With that said, if we want to hear from some other folks, and then we can ask questions. Commissioner O'Brien, I see.
Yeah, so just to put some context to your comment. I'm not surprised that we're here. It's a complex overlay. They've never done a fresh overview of 128A. So I don't necessarily share your view on that. It's part of the reason I do want to hear from more people. I do think it's a little more complex than at first blush.
Oh, no, maybe I didn't articulate my view well. I just don't like that. I never like when we have to be arbiters of stuff that's been working for, I don't know, 40, 50 years. All right, so let's go to at least since 1991. Let's go to whoever's next, Dr. Lightbound.
Why don't we go with Paul Umbrello? And let's see. Paul might have to unmute himself. My phone is at *6.
Is that correct, Commissioner? *6 to unmute.
I believe, yes.
Paul, are you able to unmute yourself?
No, I do see Director O'Toole here if he's needing some more time to work that out.
Do you want to go ahead and have Steve O'Toole go, and I'll work with Paul on getting himself situated.
If that works for you, Dr. Lightbound, it works for me.
Okay.
Hi, Steve.
Thank you, Commissioner. I would like to make a few comments. Obviously, I'm not an attorney. I'm a director of racing, but I have been involved with racing in Massachusetts for 25 years on the management side. And I was part of the negotiations with the legislature for account wagering, as well as for the simulcasting and the simulcasting restrictions. And the reason that the simulcasting restrictions are in place at the time by the legislatures, by certain legislators, it was what was coined the phrase, a delicate balance between the licensees. There was 4 licensees at the time, and it was because of the competitive nature of the business and the locations of the simulcast facilities, that it was deemed that restrictions needed to be in place. So I've heard the term that this is a complicated issue, that it's a complicated statute. To me, it's not complicated because the statute actually, as it's written, protects those interests that have live racing. And I know that Attorney Nolzo coined the phrase racing meeting licensees. That's true that the legislature has allowed former racing licensees to continue simulcasting. However, I believe that the statute is very clear that only those conducting a live race meet have the ability to have ADWs. I think that he fell short in his description of racing meeting licensees, because I believe in 5C that it does say conducting a live racing meet, and Plainridge is the only live racing meet conducting racing. So given that little bit of history, we do apply annually for the one ADW that we have, which is Penn Entertainment owned, which is Hollywood Racing. And the reason that we apply annually, which the other licensees do not, is because we apply annually for a racing license to conduct a racing meeting licensee. And furthermore, both Suffolk and Raynham are precluded under law. The word precluded is in the statute from conducting live racing. This statute, as written, even today, protects live racing. The restrictions that are in place, maybe we weren't, keeping track. I keep track of my track. I don't keep track of the other tracks and what they're doing. I assume that they follow the law. And I'm very, very disturbed from what I heard from Twin Spires, that other licensees are just, when we're racing live, or even the statute that says 4 harness signals can be taken by the other licensees, they come in, the ADWs come in through those licensees. They're bound by those restrictions. And there's 4 harness signals that can be offered. And I'm hearing today that they don't care. They don't care what it says. The ADWs just take it. So we're here in Massachusetts to an entity in Louisville, Kentucky that just disregards the Massachusetts state restrictions by the statute. That's just the tip of the iceberg. And I could go on and on and on about this because I've lived it for 25 years. I was part of the simulcast restrictions when it came in 2001. I was part of the negotiations for ADWs in 20, I'm not sure of the year, but believe me, I was here. And the other thing that I think is kind of interesting is that when these restrictions are just blatantly disregarded, we are at such a competitive disadvantage from where we sit. We sponsor live racing. There's a cost for us to do business. When all 4 licensees were conducting racing, there was a cost of doing business for each one of us. Some of us in greater value than others. And that's why the restrictions were in place. Now, we're conducting live racing at present. One of the conditions of that is that we have a horseman's share of not only our simulcast revenues, but also of the revenues that come in through the ADWs. We share 4% with our horsemen. Now, these ADWs don't pay anything. In the case of Suffolk, I believe there's a 1/2 of 1% clause that they might pay. I don't know. And in the case of Raynham, it's 0. So we are at a competitive disadvantage. That's why we only have one ADW, Hollywood Races, because it's company owned. So these other, no ADW is going to sign with us when they have to share 4% of the handle with the horsemen. So we were at a competitive disadvantage only because we're conducting live racing. And that is why conducting live racing, in my opinion, is the linchpin for this whole discussion. And the restrictions should be followed by all to this day. And actually, the restrictions should probably even go further at this point in time if there was a reconstruct of 128A and 128C to protect the live racing licensee. Thank you.
So thank you, Director O'Toole. I will note that we are regulators and not legislators for the record, but thank you for that reminder.
Chair, can I have an opportunity to briefly respond?
Attorney Nozel, MC, and Commissioner O'Brien say yes. I think that's fine. I do want to see if Paul Umbrella was able to log in, Dr. Lightbound, first.
Yes, Paul's unmuted now.
Okay.
So we can go ahead with Paul if you'd like.
Briefly, Attorney Nozel, if you would like to say something. I do not want to get into a back and forth. This is really an education piece, but go ahead.
Yeah, thank you. I understand that as well. I just want to point out, what I think should be the obvious, but it's worth restating, that the beneficiary of this agreement is Massasoit Greyhound Association, a Massachusetts locally owned family business. So if we want to talk about out-of-state interests and who owns what, I think we start with MGA and the fact that it's been here for close to 100 years. And I think that's an important sort of piece. The other piece that's very important is that both Plainridge and Mr. O'Toole appear to suggest that live racing is a precondition to having an ADW. That is not the case. There's nothing in the statute that says conducting a racing meeting, as Mr. O'Toole said today, and also as included in the comments filed by Plainridge Park. The statute is clear. It said each person licensed to conduct. And Mr. O'Toole quite correctly pointed out that MGA, as a racing license meeting holder, as authorized by the legislature, has the same rights as everyone else when it comes to that particular status. It's an important distinction, and that's what I wanted to reply to today, just based on the particular language in the statute. There is no live racing requirement.
Thank you.
Mr. Chair, may I very briefly respond to one thing Mr. O'Toole said as well?
As long as it's respectful, Mr. Silver.
No intention to not be respectful. But I suppose to that point, there was a suggestion that Churchill is ignoring or does not care about limitations in the Massachusetts statute. That's not the case. It's our position that these limitations, these statutory limitations, have never applied, whether to ADW providers contracting with Suffolk Downs or MGA for that matter. And so again, this is not out of an act of ignorance or defiance of the statute. This is us proceeding in the same manner that we've been proceeding with the Commission's permission over the years, alongside other ADWs.
Thank you, Mr. Silver, and that indeed was very respectful. Thank you. All right. Now, if we can turn to Paul Umbrella.
Thank you, Chairman Maynard, Commissioners. Can you hear me okay?
We can.
All right, thank you. Sorry I'm out of pocket and I'm not available by Zoom, but I thank you for listening to some of my testimony today. And yes, I think we can agree that I think we're all going to disagree. And I want to add some more light into this, is that I don't think when this antiquated legislation was written many, many years ago, nobody put in a clause that said in the event there's no longer live racing, thoroughbred live racing in Massachusetts, we put a contingency clause in place. So unfortunately, with the closing of Suffolk Downs in 2019 officially, and we, the Thoroughbred Horsemen, are still actively looking to build a racetrack. Some of my concerns have been, and I thank the Commission for rightfully so delaying this vote today, is because, and I'm not going to get into agreeing and disagreeing with the other parties, but I don't believe in a live racing element shouldn't apply. It's why we still have our breeding program and health and welfare programs should still survive today without live racing or until live racing returns. I also disagree in the sense that my concern has been it's live thoroughbred racing, or thoroughbred racing is the signal coming in, not a harness signal, to Mr. O'Toole's comment. But my biggest concern has been is those ADW contracts through Suffolk Downs, which has been and always been the live thoroughbred racing track. As I mentioned to the Commission in the past, under the Interstate Horse Racing Act, which is federal law over state law, it clearly defines the NEHBPA and our consent to take those signals in. And those signals through live racing, simulcast, and ADWs, regardless of how they're defined today and its interpretation that we all have, and I myself am not an attorney, it's really, all those were designed just like the 2011 Gaming Act, which we were instrumental in, is to protect the horsemen, thoroughbred and standardbreds. And that's always our request. But our contract negotiations with Suffolk Downs, every year we sign off on a person recognition agreement with our consent that, regardless at times what those percentages are, and they're collected through simulcast or ADWs, we agree to take in premiums at this time from Suffolk Downs. And now when you're going to take $50 million, if I use 2024's numbers, off the table, that now impacts my bargaining chip and now gives MGA the opportunity, which, because when dog racing was banned many, many, many years ago, they are now theoretically do not owe us premiums due to us that they paid us in the past. Same goes to Plainridge Park, right? We've set a precedent, regardless of what the law said or has said, the precedent has been set, right? And counsel for MGA who said a contract is a contract is, it doesn't matter. No, again, I'm going to disagree. So my point is that O'Toole stopped paying us, Plainridge Park stopped paying us, Plainridge paid us premiums because live racing ended in 19. The dog folks stopped paying us premium because dog racing was banned. That still doesn't matter. Those signals should come in, and the Thoroughbred Horsemen and our association to keep our programs going should not be paid for those premiums. So that's been my biggest concern when I heard that Suffolk Downs, and I'm still been trying to, and you saw my letters and comments, last minute, I'm still trying to talk to all the necessary parties and find out, what's in play, what do the contracts look like. Sue Rogers did call me early this morning at 9:30. I have yet to call her back because, again, as I said, I am like you, still trying to figure out what's going on. But I think I voiced my concern that, again, There's a lot to discuss. We've been talking about how 128A and C definitely need a rewrite because of their interpretations and how they're so antiquated. But I'll leave it at that, and I thank the commissioners for their time.
Thank you, Paul, and we appreciate your perspective. And I have to go back and say, Mr. Silver, the reason I asked that question is because everybody else on the call deals with the commission a lot, so they already knew to be respectful. That's the reason I asked it that directly. So
I was concerned that maybe I was concerned that perhaps my reputation preceded me somehow.
No. Attorney Nozel and Paul and Steve, they all know the drill. So. All right. So
yeah, I did just want to add again, I'm not making a new argument here. I did want to verify or confirm that Raynham or MGA has reached out to Paul. Obviously, we just saw his comments yesterday. And we may disagree with him on the legal foundation for those, but we do certainly feel that a dialogue would be important. To be frank, they've lost a lot. MGA has lost a lot. We understand where they're coming from. And certainly we want to have a dialogue with them. And you have our word that we are going to do that.
Mr. Chair, if I could add just two brief comments. These are just for the edification of the commission, just given all the comments we just heard. I will just sort of circle back and point out what I led with here, that I think the critical component here is that there is a reference to following 128C in 128A. And I don't think that has been squarely addressed by the parties, aside for a narrow interpretation of that by Churchill Downs in their letter. So I think that is one preeminent issue that I would respectfully request that the party, not today, but that the parties may want to submit something in writing on. And then subsequently, I know there was argument about, well, past practice was done and something may have been approved in the past or for years prior. The principles of estoppel do not apply to a government agency. So that may well be the case. This is this commission taking an opportunity, and you have the rights, as you have this current composition of this commission, to review this anew, and you're empowered to do that. So I just wanted to let the commissioners all be aware of those two issues.
Thank you for that, Councilor Stepek. And I just want to take one thing off the table right now, and I heard it 4 or 5 different times. This should not be viewed as an opportunity to rewrite the statute. Again, that's not our job. We're not legislators. We do have the ability to interpret our statutes, and that is well-founded in the Commonwealth of Massachusetts, our ability to do that, and we will do that. I made the joke about, how I was just enjoying my summer until this issue hit. But in all seriousness, we will make, the final determination. That's our jobs. But I will say, the easier our licensees make this on us, the easier we can make a decision. And if there's some agreement, and Mr. O'Toole, you talked about the balance of the equities that existed many years ago. If we can balance those equities, and by we, I mean the licensees, it will help us, I think, make determinations. So I would encourage that opportunity for collaboration anytime there is an opportunity for one. With that, commissioners, you've heard everything. Do we want to tease out any of these issues or ask for anything to be briefed for us in particular?
No, but no, just to second Justin's request on the last point. That would be helpful for me if that was put in writing.
Any other requests, commissioners?
Mr. Chairman, I don't have a request, but for me, a lot of the questions that I have are really for internal questions with our staff. One of the for me anyways, one of the big elephants in the room for us that we need, to understand, and it's been brought up a couple of times, is why was the law with restrictions allowed for so long in the past? And as I see it, the law has been now brought to our attention by staff. And I want to let everybody to publicly know, we have new commissioners now. So whatever happened in the past is the past. We have 5 new commissioners now dealing with this issue. We have new staff who are going through our laws and our regulations with fine-tooth combs now, so that every issue that is brought to us publicly or privately is done through a new set of lenses compared to, our past friends who served in these positions. So the question I'm going to have for everyone is, once all this information's been brought to this commission, how can I do anything but adhere to what the law says? And over the next few days, it's going to be our job to decipher what that law says exactly. And it is a little more complicated than the folks on the screen are letting, us all to believe. Because there are different sections of the law, I think, that we have to look at when it comes to this issue. But as one commissioner, I'm looking at the law and I can't deviate from what is being told to us by staff and others. And that's why I'd asked that we put this off today. This has been great information, and I thank everybody for coming before us. But that's the big issue for me. What's happened in the past, I wasn't here. I have to now look forward. And I think we're all trying to do that now, as commissioners and as staff. So I just wanted to make that statement, Mr. Chairman.
Thank you, Commissioner Hill. I will say that we have approved signals. At least 4 of us have in the past. So it begs the question I would add to your line of questioning there. Why wasn't this brought to our attention when those signals popped up too? Right? Why is this issue popping now? Would be something I'm interested in, not necessarily for today, but maybe be added into those comments. Commissioner Skinner, Commissioner Broder. You're good, Commissioner?
I'm all set for now, Mr. Chairman.
All right. Anything else that needs to be said here today? All right. I want to thank Rainham and Mr. Silver and Mr. Nozel and Mr. O'Toole and the Horseman Association for coming here today and speaking with us. We appreciate your perspectives, and we're going to get to work to try to make some decisions. Again, we look forward to additional comments, and perhaps, as Attorney Nozel has just previewed for us, some solutions to work together among the properties and the interests here. And thank you, Paul Umbrella, too. All right. I'm going to ask.
Thank you, Commissioners.
Thank you.
Thank you.
Thank you, Sue.
Thank you all.
Thank you.
Thanks, Chair.
Steve. Andrew. I'm going to be in Louisville in a few weeks. So
You're from here. You say it better than I do.
it's Louisville. All right. Can we take a 5-minute break? All right. Thank you. All right, I think we can take that down. It took me a little bit more than 5 minutes. As I want to do, I walked into the hallway and there are a lot of team members in today. And so I got caught up in a conversation. All right. This is a reconvening of the Massachusetts Gaming Commission meeting. It is approximately 11:34 a.m. So good morning again, Commissioner O'Brien.
Morning.
Good morning, Commissioner Hill.
Good morning.
Good morning, Commissioner Skinner.
Good morning.
Good morning, Commissioner Broder. He's here.
Good morning.
Good morning. All right. We have to do that because we do hold these meetings virtually. We just left off on item number 7, and for that, we are going to kick it over to the Chief of Sports Wagering, Carrie Teresi. It looks like Manager Steffens also joining us.
Yes, thank you. Good morning, Chair and Commissioners. We have one set of House rules for you today, and for that, I will turn it over to Andrew.
Thanks, Carrie. Good morning, Commissioners. Beginning on page 73 of your packet, we have one House rule revision for review today. This comes from Fanatics Betting and Gaming. Fanatics submitted these revisions to our division on June 13th with relatively minor changes. The first revision within their general betting rules makes a change to how their teaser odds, how teaser odds will now be based on the odds of each individual pick within the teaser rather than a fixed payout chart. Moving down to baseball, there is a very slight change to markets for games that are scheduled for 7 innings. The language now states for games that are scheduled for 7 innings, the game must go at least this full 7 to have action, unless the result is already determined. This change really just clears up any ambiguity in 7-inning matches. For hockey, the listed market for first, next, or specific goal will not include overtime or shootouts unless it is explicitly stated within the market selection. This is a trend that we've seen from operators going back and forth between including overtime or not within certain hockey markets. Looking at other operator house rules, we have no issue with this change. And then lastly, for mixed martial arts, they have added a new market for fight spread. And Fanatics has listed the appropriate language for this new market, as well as giving a clear example if the fight goes to a decision or the full 3 rounds on how the wager is settled. And that concludes our quick yet thorough review for these changes today. We do have Fanatics State Compliance Analyst Chris Mackey on the meeting to help answer any specific questions from their end. However, we would recommend the full approval of these changes today. Chair.
Thank you, Andrew. Commissioners, questions for Andrew or for Fanatics?
Mr. Chairman.
Commissioner Hill.
I have no questions. I would rather move that the commission approve the updates to Fanatics House rules as included in the commissioner's packet and discussed here today.
Second.
Thank you. Any further discussion? Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes, 5-0. All right. Thank you.
Thank you, Commissioners.
All right. And I see Dr. Volberg on the screen. And for that, we're going to turn it over to item number 8, Director Vanderlinden.
Thank you, Chair Maynard. Good morning, Chair and Commissioners. Today we have a report to deliver to you titled Diversity in Sports Wagering and Recommendations for Future Practices in the Massachusetts Industry. I'm joined by Mark Melnick, who is, sorry, Mark, I want to make sure I get your title correct. Director of Economic and Policy Research at the UMass Donahue Institute. Mark is also a co-principal investigator on the STIGMA project. We also have today Dr. Rachel Volberg, and just a clarification on the agenda, it's not quite right. Dr. Volberg is actually doing this work under Gemini Research, which she is president of Gemini Research, not under the STIGMA project. There were two statutorily required studies under the Sports Wagering Act. One was looked at the feasibility of sports wagering kiosks in Massachusetts, and the second one, which is being presented today, was guided by Section 25 of House Bill 5164, which required the Massachusetts Gaming Commission to conduct a study on the participation by minority business enterprises, women business enterprises, and veteran business enterprises in the sports wagering industry in the Commonwealth. Mr. Melnick and Dr. Volberg will walk you through that study. Also in your packet today was a research snapshot that Dr. Andrews created for us to help simplify it. And so with that, I will turn it over to you, Mark and Rachel.
Oh, there we go. Sorry, I was muted. Mark, you stripped a degree from me. So, good morning, everybody. I'm Mark Melnick. I'm the Director of Economic and Public Policy Research at the Donahue Institute.
Mark, I truly do apologize for that. I usually try to make sure that I
No, it's fine. I'm just teasing you. Chairperson, commissioners, thank you so much for the opportunity to get to speak with you today. This study, as Mark already set up for us, is really an early snapshot of some of the activities that we've seen so far in the sports wagering ecosystem in the Commonwealth. Rachel and I will be presenting on this material. I'll do most of the presentation, but Rachel's available for any questions that you guys may have. Interestingly, while this was not done as part of a SIGMA project, a lot of the learnings that we've had as part of the SIGMA team over the last 12 years really helped, inform some of the things that we've been doing on this project as well. I wanted to do a quick shout out to obviously Rachel for her collaboration on this, but also the members of my team, Becky Loveland, Tom Peak, Rye McKenzie, and Cassie Breest. All those are names that you guys may be familiar with from other projects that we've done with you all, but were really instrumental in the work that we were doing here, as well as the support from Mark and Bonnie along the way. So with that, let me share my slides. Okay, so did the preamble. So this first slide here provides a brief history of the legalization of sports wagering in Massachusetts. The potential for legalized sports wagering across the U.S. became possible in 2018 when the Supreme Court declared the Professional and Amateur Sports Protection Act of 1992 unconstitutional. This opened the door for individual states to pass legislation to introduce sports wagering, which 38 states and Washington, D.C. have done in the 6 years since the PASPA decision. Building on the 2011 Massachusetts Expanded Gaming Act, the Commonwealth legalized sports wagering activities in 2022 through an act to regulate sports wagering. The Mass Gaming Commission was tasked with overseeing the sports wagering industry from that point. And here we have a lot of the just kind of the major touchstones along that way. So this particular research, as part of the legalization of sports wagering, the Massachusetts legislature required the Gaming Commission to conduct a study concerning diverse participation within the sports wagering industry. The RFR was very specific in its definition of diversity, where for this particular study was focused on the participation of racial minorities, women, and veteran business enterprises, and about the participation of racial minorities, women, and veteran workers in the sports wagering industry. Obviously, there could be other ways to define diversity, but these are the ways in which it was focused on for this study. Broadly, the study is aimed to inform the MGC on ways of expanding employment and vendor diversity within the sports wagering sector, which is obviously the newest area of gambling activities in the Commonwealth. So what did we do? As required within the RFR, the study examines conditions in Massachusetts sports wagering industry among three main groups. First being the operators who offer retail and online sports wagering activities. These are often referred to as category 1, the retail operators or the bricks and mortar casinos that we currently have in the state. In category 3, which are the online mobile online mobile operators. Category 2 includes simulcast and race facilities, but there are no licenses for those right now. The second element of the key players in the space is obviously the Gaming Commission itself and its role as a regulator of the industry. And then lastly was a particular call out for the study focusing on advertising, marketing, and promotional firms that provide a wide range of services for the sports wagering industry and are often the most significant subcontractors within this sector. The operating license types, which I alluded to a little bit before, Mass General Law C-23N creates license categories for 3 distinct types of sports wagering operators based on modes of play. In-person gambling at casinos, which make up the category 1, and I already mentioned that before, so that includes Encore, MGM Springfield, and Plainridge Park Casino. Category 2, which are for certain racetracks and or simulcast centers to offer in-person sports wagering. There are no licenses for that right now, so are not included in any meaningful way in the study. And then the category 3, which make up our online mobile operators offering online sports wagering. The 8 companies you see here are the ones who were awarded licenses early in the sports wagering legalization, 2 of which did not renew licenses in 2024, so were not included in the study. So we just focused on those that received licenses in 2023 and continued on. Most of the analysis that we're looking at here with our data covers 2023. One thing I did want to call out, though, is you'll notice ESPN Bet there on the graphic. Throughout much of the written report, that was referred to as Penn National, and there was a name change, but these are the 3 different types of operators. In terms of our research strategy, our work kind of fell across 3 main phases. There was our phase 1 data collection period, which we'll get into a little more detail on the next slide, but that included research for defining the sector. We also conducted key informant interviews, which was largely done by Rachel and her team at Gemini Research, and then collected data from operators and the MGC. And during the analysis phase, we analyzed diverse participation in program policies, created quarterly averages across the entire industry in accordance with data use agreements, so that none of the operators were identified, but rather operator types. So we'll talk often in this presentation and in the report itself about mobile versus retail. And then did a comparison of diverse participation in similar industries as sports wagering. And some of this is stuff that we've done in previous studies as well. And then last, we create a number of recommendations to identify best practices for employment and vendor diversity programs. A lot of this is inspired by the success casinos have had with their targets and programs, with consideration for the levels of participation that already exist in the industry. For data collection, we used a mixed methods approach. On the qualitative side, our work mainly focused on an operator questionnaire. This was developed special for mobile and retail operators, and the questions we asked were mainly around employment trends and policy, vendor spending trends and policy, general questions about the process of expanding into the Massachusetts market. And then the answers from this helped inform our analysis of programs and policies regarding workforce and vendor diversity and spending related to expansion into Massachusetts and some of the assumptions regarding the mobile sports betting industry in general. The second qualitative exercise was the key informant interviews. We conducted 22 in-depth interviews across 10 different organizations, including retail and mobile operators, as well as the MGC, to help inform strategies or our recommendations and understand the context really of what the experiences are when it comes to diverse spending and hiring within the industry. On the quantitative side, we analyzed a lot of workforce and payroll demographics and payroll data. We provided data requests to all the operators asking for counts of employment and compensation paid to employees across locations, Massachusetts and the US mainly, and across diversity categories as we've already defined them: women, minority workers, veterans, and job levels, entry level, mid-level, and top management. And again, these data helped inform our understanding of the participation of diverse employees, their compensation, kinds of jobs they do, and so on. And then we also collected vendor spending data. This was a data request to all the operators asking for counts of vendors and dollars spent to vendors across locations and diversity categories, and again, informing our understanding of that spending across those same categories. So what did we find? On the qualitative side, the small size of the sports wagering industry in Massachusetts limits the number of diversity initiatives and policies at both the employee and vendor level. Popular perceptions of the industry tend to skew towards younger segments of the population and white males. And this seems, in some of the observations from folks in interviews, theorized that this was harming recruitment and retention for diverse employees. Employee resource groups that promote a diverse workforce and encourage advancement may contribute to retention of diverse employees and are things that may be considered for future policy. The primary barriers to contracting with diverse vendors is the limited number of significant purchases, which beyond advertising and marketing tend to be specialized and sole sourced. So unlike casinos themselves, which are quite large and have a lot of different moving parts to them, the elements of sports betting within the casino are kind of small, or a smaller part of the entire organization. Or when it comes to the mobile, it's a different set of kind of vendors that they would work with. And so it tends to be somewhat specialized. Additional barriers to contracting with diverse vendors can be the cumbersome process of certifying as a diverse owned company in Massachusetts and as a licensed MGC vendor. This is an issue that we've heard many times when we've been studying different elements of diverse procurement in the state, is that the process to be a certified a supplier diversity business can be difficult, especially for a small business. And so that can provide a bit of a barrier as well. On the quantitative side, sports wagering in Massachusetts, as I noted before, is a relatively small industry, and this is also the case when we think about employment and vendor spending. We found that retail sports wagering employment is so low, it is more accurate to consider it as a part of casino operations. After all, a lot of those employees were working both in casino departments and the sports betting departments. And many of the jobs in Massachusetts in mobile sports wagering were here before legalization, mainly because Massachusetts is home to one of the larger mobile sports operators in the country. The national industry compares well to similar industries in terms of diversity in average compensation, though the industry is comparatively less diverse within Massachusetts. Women and minority workers and vendors participated at higher rates than veterans. But overall, there weren't any strong trends across operator type and diversity categories. So moving to some industry overviews, I'm going to talk some about program policies and industry perspectives. There really weren't any super noticeable trends or differences here. Basically, all operators have programs and policies in place to some extent. None of them are particularly notable or have standardized metrics or targets, though. On programs and policy, all license holders and the MGC have programs, policies, and practices in place related to solicitation of and contracting with minority, women, and veteran-owned enterprises. Retail sports operators in the MGC universally have programs and policies to increase levels of engagement, volume, and scale with these businesses, as do nearly all mobile sports wagering operators. On the industry side, operators emphasized that vendor spending was generally limited to a few specialized companies, and there wasn't much opportunity for diversifying their spending with diverse businesses, though we have a number of recommendations that point on ways to improve there. Some industry overview stuff, and to orient you to this graphic. The figure on the left shows mobile versus retail employment in Massachusetts and the US right now. And it shows the number of and then on the right, excuse me, shows the number of suppliers who received a payment from an operator in each category. DraftKings had around 1,000 employees in the state before legalization, so we don't really consider that to be new or created employment because of legalization. And we were mainly looking at the average quarterly, and then on the supplier side, we're looking at the average quarterly spending throughout the year of 2023. But as we can see, both the number of jobs within the sports wagering sector, as well as the number of supplier transactions are somewhat modest. On workplace diversity, this next graphic just looks at some of the makeup of the workers within sports betting and what some of those characteristics look like. On the left, we see mobile versus retail, minority, women, and veteran workers. Obviously, there's significantly more racial minority and female workers in the sector, still quite modest for veteran. One of the things that was really interesting to me, though, was the compensation differences, and I think it speaks a little bit to the ways in which a casino is actually quite different than online betting, right? So on the left, we see the mobile sports betting and what the quarterly wages are within the sector. And on the right, we see what the wages are quarterly in a retail sector. So unsurprisingly, the retail sector wages look quite a bit like the wages that we would see for folks who worked in a casino. And because these are people who are working in a casino. On the mobile side of things, though, what we're really looking at is a technology company. And so a lot of what the wages we're seeing here are quite elevated and are more in the space of IT or other forms of computer platforms, right? So wages that are quite a bit higher in those instances. When it comes to comparison between similar such industries, we use some of the comparison industries that as we have in other places in our Sigma work. So on the left, what we're comparing here is the mobile workforce within sports wagering versus software publishing as a sector. And what we see here is that while there is pretty good representation of racial minorities and women within mobile sports wagering, it still doesn't look quite as diverse as it was in software publishing. I think it may speak a little bit again to online sports betting is the domain of young white guys, and so what that stereotype of the sector may look like. On the right, similarly, we're comparing the retail with traveler accommodations, and that's been a comparison group we've used in the past as well. And here, the retail sports betting looking diverse, but not as diverse as traveler accommodations. Switching to vendor diversity and spending here, sports betting operators spend relatively little on outside vendors and usually contract with only a few suppliers providing specialized products. Thus, there are few opportunities and not a large pool of businesses for them to diversify their purchases. Few of these vendors are based in Massachusetts, and only some are certified as diverse businesses. The MGC mentioned that the most plentiful diversity-owned companies are women-owned, facilitating contracting with them. So here what we see is some differences here between spending for non-diverse business enterprises and diverse business enterprises, mobile having a small concentration of minority business enterprises and even smaller women, and none with none of any significance with veterans. On the retail side of things, obviously a lot of the contracting is happening with the casino itself, and there's a very small portion of it that's happening with retail sports betting. Now, an excellent opportunity for diversification, however, within vendor spending is around advertising and marketing. Just under 40% of retail vendors are of retail vendor spending is, excuse me, let me do that one more time. Just under 40% of the transactions are with marketing and advertising firms, but that accounts for 90% of the spending. And there's virtually none of that money that's being spent right now with diverse vendors. So there's a great opportunity there for expanding some of the opportunities for DBEs in Massachusetts. Similarly, 30% of the transactions for mobile vendors are marketing and advertising firms, but account for 50% of the spending as well. And there was no dollars spent among our online sports books on marketing and advertising with DBEs. Looking at diversity within the MGC, this is some data that we drew from reports from the Gaming Commission itself. We see that the industry is pretty, or excuse me, the MGC's makeup of its workforce is pretty diverse. It's 55% male, 45% female. This is a little bit behind the split for public administration and other forms of government in the US in terms of female workforce participation, but not dramatically so. In terms of race, we see some similarities with the public administration, or excuse me, the Massachusetts workforce as well, where the white population is about right on average, with slightly higher percentages of Asian and Black workers at the Gaming Commission and slightly lower for Hispanic. I think really excitedly and a great success for the Gaming Commission has been their spending with diverse vendors. We see there in the red, and we're looking at the graphic on the right, in the red, we see the benchmark goals for the Gaming Commission in terms of spending with certified diverse providers. And then the yellow being the actual spending in fiscal year 23. So with minority business enterprises and women business enterprises, the Gaming Commission far exceeded its goals as a benchmark. For veteran business enterprises, they are below the benchmark, but they more than make up for it in the other categories with women-owned and minority-owned business enterprises. Okay, transitioning now to a handful of recommendations. We split our recommendations into three main categories: recommendations for the operators, recommendations for the Gaming Commission, and recommendations for state government. In terms of the operators, our first recommendation is to encourage development of workforce diversity goals and standardized metrics for mobile sports wagering operators. Casino programs and policies are structured towards meeting workforce diversity goals for minority, women, and veteran participation, and these programs measure progress with standardized metrics. The Gaming Commission could expand their approach for their own policies and programs to encompass all these types and establish helpful metrics for evaluating the success of their efforts, and could recommend the same approach for licensed Category 3 operators, particularly as it relates to Massachusetts related workforce. On supplier diversity, our first recommendation is encouraging operators to create strategies and measurable targets to increase the participation of diverse vendors. The Gaming Commission has a smaller role in regulating the sports wagering industry compared to their regulation of the casino operations, due to an absence of legislation mandating operators to establish targets or implement diversity initiatives. That said, sports wagering retail operators should be working within the rubric of what some of the things we see with the casino supplier diversity programs, and develop policies to increase diversity will really only be implemented if the MGC can influence the Category 3 operators. In spite of limitations, the MGC could actively encourage Category 3 operators to adopt approaches to increase supplier diversity related to their Massachusetts-specific operations. The MGC could offer recommendations and resources to operators who seek to promote opportunities for diverse businesses within the industry. For example, encourage the development of workforce diversity goals for recruitment and hiring, establish and standardize metrics to allow assessment of the effectiveness of programs and policies over time, and asking operators to provide information on diversity initiatives, goals, and progress reports, as with land-based casinos. Other recommendations for the MGC would be to support businesses to apply for SDO diverse business certification and small business purchasing programs while registering as suppliers for the Gaming Commission. We've heard this in a number of places, the difficulty for diverse businesses to receive certification, or especially when we talk about really new and small businesses that may only have a handful of employees. So the paperwork and the effort that it takes to get certified can be a challenge. So any kinds of supports that can be offered through technical assistance or otherwise to get more businesses certified is just it would just be have positive outcome when we think about general spending. According to interviews, the requirements present hurdles for many diverse business owners just for these different types of certifications. The second recommendation we made is create and maintain a marketing directory to provide broader exposure for businesses with relationships to the industry, including those that have diverse ownership. Again, just trying to create, leaving more breadcrumbs behind for making that connection between businesses, between our licensees and local businesses who are able to support them through the different business support activities. And then broaden diversity requirements to accept alternative types of diverse ownership certification. There are some examples of this nationally of alternative certifications. For example, one commonly mentioned through interviews is the Suppliers Gateway Enhanced Digital Certification, EDC service. Articles about this certification describe the benefits of a faster, more affordable supplier certification process for eligible businesses. So exploring opportunities like that may make it easier for small businesses to get on a list and then be selected as a potential supplier. And then for state government, our recommendations mainly focus on how to direct different elements of the sports wagering taxes to support diversity. So the first one, directing sport wagering tax revenue to support workforce development. Of particular relevance here, I think, is around ESOL training and in helping reduce barriers of potential employment for diverse workers in the field. A second is direct sports wagering tax revenue towards organizations, programs, and initiatives that support diverse businesses. Supplier diversity programs and policies alone cannot solve the broader structural issues and mismatches that constrain the capacity of minority-owned, women-owned, and veteran-owned companies to engage with the industry. As discussed throughout the report in several places, larger economic factors are at work when it comes to improving supplier diversity in the sports wagering industry. And as discussed in the industry perspective section, operators we surveyed report that they maintain programs meant to increase diversity in solicitation and contracting, most commonly through partnerships with local and national business advocacy groups. However, across the board, licensees emphasize that vendor spending was generally limited to just a few specialized companies, and there weren't as many opportunities for diversification. So finding ways to kind of break down those barriers would be important. And in using sports, and then the third, using sports wagering taxes to create a permanent and significant funding stream for small business development and technical assistance is somewhat related to the point I made with the Gaming Commission, but wanting to continue to underscore is that if we want to try to get more diverse businesses working with these large anchor institutions, as it were, with the casinos themselves or with the mobile sports vendors, this recognition of certification being important for driving people to these diverse vendors, but recognizing that that certification does create a challenge for businesses as well. So how do we make that certification process easier in using resources to that effect? So with that, I will stop my presentation and happy to answer any questions. And we'll also refer to Rachel on some of these as well.
Thank you, Dr. Melnick. Commissioners, questions, observations? Commissioner O'Brien?
Sure. Yeah, thank you. I wanted to follow up on your comment about sort of the women's numbers in the sports wagering industry. It seems to be industry-wide, but is it particularly noticeable in Massachusetts compared to national averages, or is it consistent with that?
I think we were slightly lower than national averages, but not in a sense that was like wildly different. So I do think that, you know, part of it, I think is the makeup of the historic understanding of the industry. And I do think that it's worth noting that we also have a different industry makeup in Massachusetts as well. So you may have some elements of this where, you know, female population with who are well educated, working perhaps in higher wage sectors of the economy. You could see where that disconnect can happen as well, but that would require further examination.
Okay. So I think based on that, you're probably going to say the same thing to the next question, but is there a way to differentiate supervisor management positions in terms of that?
That is in the report. Is in the report. And I don't recall the exact statistics off the top of my head, but check in the report. And we do distinguish between entry level, mid-level, and then executive level.
Okay. And nothing that I don't know.
No wild trends in my mind that were.
Nothing pops up, right?
Yeah. Rachel, do you have a different take on that?
No, but I think I was struck that, you know what, I was going to cite a number and I probably shouldn't because I haven't looked at the report for a while. But there was something that stood out about the proportion of women in the sports, in the mobile sector of the industry, the proportion of executive level people that are women.
Mm-hmm. Yeah, I'm not surprised to hear you say that, and likewise, I'm not going to throw numbers out, but I'm wondering if there's anything beyond sort of what's been presented, or you go back and see that number, and there's anything you wanted to add. I'd love to hear it. I know I'm not going to put you on the spot now, but
yeah, I'm paging through right now just to check it. But other questions or comments? Or I'm sorry, Chairperson, you run the show, not me.
Dr. Melnick, you're the first person to tell me that in a year and 4 months. So thank you for that promotion. You gave me a promotion.
Yeah.
Commissioner Broder and then Commissioner Skinner, Commissioner Broder, I saw them both go off. Who wants to go first?
Just quickly, focusing on the findings, particularly those around diverse vendor support. The commission recently undertook a diversity audit of its Category 1 licensees, and I'm seeing some overlap in the findings that you have presented to us with respect to the difficulty that businesses experience in getting certified, for instance, and what the findings were as a result of this audit. And so we have developed a subgroup to dig into those findings in a little bit more detail. Executive Director Serpa knows what I'm talking about. Some of the legal team knows what I'm talking about. And so we're going to be bringing forward in the near future some recommendations that are designed to assist in that vein. These recommendations that are coming forward are focused on the Category 1 licensees, but I think if adopted by the commission, ultimately it's the diverse business vendors who stand to benefit from some of the changes we are going to be proposing be made there. I should have started with this, just a thank you to Mark and his team and Dr. Goldberg and you. Is it Dr. Melnick? I wasn't.
It is Doctor. I'm sorry. It's fine. But Mark is. I feel much more comfortable with Mark. So
Yeah, I wasn't clear what the discrepancy was, so I want to make sure I'm getting it right. But thank you so much for presenting to us today. It's really interesting, food for thought, and I think it gives us a lot to chew on over the next several months and perhaps years as we try to make some headway in this very important space.
Thank you, Commissioner Skinner. Commissioner Broder.
Thank you, Mr. Chairman. I want to start by dittoing what Commissioner Skinner said about our thanks. He's supporting our mission, which continues as we sail into some fairly challenging waters, certainly on the national level around issues like this. I'm curious. So we have partnered at least on one occasion with the Supply Diversity Office to do a couple things, to try to make connections within the industry, but also the SDO as part of that event did a tutorial or an assistance for folks who might need help navigating the certification process. So I'm wondering, do you think we need to take on a particular focus role in that endeavor, or to be more productive or more efficient to continue to seek the support of SDO in doing that work?
Richard, you want to take a first swing?
I think it's a matter of both of the above. And I'm just going to reference the fact that my business Gemini Research is certified. So I've been through that process, and I can tell you it was like being audited by the IRS.
I've heard stories, for sure, for sure.
So I think there is definitely a role for the Supplier Diversity Office to assist women and minority business owners who are contemplating that process. In terms of, they do have some trainings that you can do online. And I've seen various workshops that have been announced. But I think it once I started reading through the paperwork requirements, it was very, very daunting. And would be for, I think, any business owner.
Sure.
I think from the perspective of the Gaming Commission, obviously partnering with SDO is important. But I think, sort of because of kind of the nature of the purchasing that the Gaming Commission does, I think there could be some work done or some efforts taken to sort of educate business owners about what kinds of services the Gaming Commission does purchase, and sort of encouraging people in those sectors to consider certification.
So do you think it's fair to say we have kind of a two-part problem? We have a small pool of folks who have navigated the system with more facing challenges, comprehension, resources, the smaller the business, the harder it is to devote time to something like that. And also just a smaller pool of folks or enterprises that may qualify at all. You kind of have to do both. Does that make sense?
I think I'm going to throw that one to Mark.
Yeah, and I do think it's both, right? It's interesting because similar to Rachel but different. We at Donahue Institute end up contracting with a lot of SDPs for different state contracts or local contracts, right? And I can't tell you. So I take meetings with folks who want to be subs with us a bunch, right? And the number of times I've heard somebody complain about the challenge of just, and I think from my end of it, as somebody who believes in the intent of the policy and the seriousness of the certification meaning something, right? We don't want somebody to take advantage of a program that's meant to break down structural inequities and then have somebody, lying about ownership or whatever, so they can get
You can fudge the structure, right? You in particular small business, you can kind of fudge the structure a little bit so that ownership on paper might be a little different than who's an active participant in the business.
So there's that, but I also think that in terms of the pool itself, there is a broader issue around generational wealth and inequities when it comes to race, and we know this in our state in particular with the legendary Federal Reserve report from 10 years ago about the average Black family in Massachusetts having a net worth of $8 versus over $200,000 for a white family. And a lot of that is around generational wealth. The businesses a lot of small businesses require tapping into wealth resources, right, that allow you to take a risk. And so I do think there's the part about like, hey, we have this administrative pain in the butt how do we break this down a little bit, while also how do we support innovation and entrepreneurship, especially in communities. So obviously you guys are just one entity amongst a constellation of entities that can be useful. So I do think there is this part of, hey, putting your money where your mouth is about like where the Gaming Commission wants to affect the world with policy, but then also being like, hey, you know what, there's actually a bigger economic development state issue here when it comes to wealth creation and how do we positively impact that, and I honestly, I feel like that's some of the really exciting things for the Gaming Commission as a commission matures, is that, hey, this is an industry that's maturing. And so what are the different ways in which, in the first couple of years, it's like, how do we just get this plane off the ground? And then now it's kind of like, how do we affect, the Commonwealth in ways that are most positive, and especially in an evolving world, right? Now we're facing an economy that doesn't look as healthy as it did a year ago or 2 years ago. And so when you're saying things like that, you're like, well, there are different times for those policies to come into play and when they'll be effective, right? So, but yeah, it's a number of challenges within that.
No, it's great. But I mean, I think of that like, a fundamental challenge is access to capital, right? For first, depending on the nature of your business and what you're going to do. But if you can't get capital, we can try to encourage your entry into the marketplace. But with a fundamental challenge like that,
right,
all this other work becomes secondary, right? If the businesses aren't capable. This is going to sound like a little bit of a ding on the SDO, and I don't mean it to be. I want that to be clear. So they do have. It seems like from their website, some fairly robust resources in terms of, creation of a directory of certified businesses and a dashboard that seems like it'd be pretty handy for folks that are looking to hire diverse vendors or contract with diverse vendors. Is it correct to say that those aren't having impact in the marketplace, that those aren't maybe taken root yet, and that those need to be propagated a little bit more?
Rachel probably has touched this more directly. I think more generically, I would say that there's the internet giveth and the internet taketh, right? So it's like there's a lot of information that's out there, right? And I do think that it's how do we make it easier I think a little bit about like the business front door stuff, like the governor's office had been developing over the last year, and some of the things that were tied to the economic development bill. It's like, so how, it can be daunting just to find the information, right? So making sure that people are aware that stuff's out there. Rachel, I mean, somebody who's had to, probably navigate this more directly, what are your thoughts?
Yeah, I mean, I I found the materials that were available on the STO's website incredibly helpful. But it also, because of the amount of and the different types of materials that you had to assemble, and sort of, speaking to the capitalizing a business issue, there were significant legal and accounting costs to generate the documents that I needed to get certified. And then perhaps most daunting of all was the interview that you have to have, with one of their investigators, who's asking very probing questions about what is the true nature of the ownership of this business? What does this business do? I mean, it ended up being a very interesting conversation. This person hadn't ever, had anything to do with a vendor of my type. Research services doesn't seem to flow across their desk very often, but it did require significant time, but also resources, to make sure that I had all of my accounting records. You have to submit a number of financial reports. You have to submit, in my case, I'm incorporated, so I had to submit my incorporation papers. I had to prove that I was, registered with the Secretary of State, et cetera, et cetera, et cetera. So, to the point that you don't want people to sort of slip in without being, vetted. It was very thorough vetting. But I do wonder about, someone who, is just starting a business. I mean, I've been in business for quite a long time. And so if you're just starting, maybe you don't have that understanding of all of the pieces that you need, or you don't know where to go get them. And I think I completely understood when folks were telling us in the key informant interviews how how difficult it was to get people to go through that STO certification.
So it's a real challenge and an understandable one, right? We want efficiency, and we want, for lack of a better way to describe it, fraud protection, or making sure that we're getting the results and advancing the initiative, the baseline policy of diversity correctly. And that's like the classic government challenge, right? One more question. It's not really, it's more of a commentary, or just an inquiry, as I'd say. We don't talk a lot about the disability community, in particular the intellectual disability community. Not necessarily a great match for our marketplace, in certain respects anyway. But do you have any comments on that particular subsector of diversity work? It's always a challenge. The unemployment rates within, particularly within the intellectual disability community, are very challenging. Is there any work to be done there that you think the commission could be helpful with?
So I have a few thoughts on this. I mean, we've done a little bit of research in this space at the Donahue Institute, in part because, which is different than I think what the intention of this research was, or this conversation, but I still think has some relevance. There's been a lot of conversation in recent years about a silver tsunami and a graying of the Massachusetts labor force, and so a lot of the answers that people come to about that is affordability in Massachusetts and making Massachusetts an attractive place for people to come and live, be it people migrating from other parts of the US or immigrants, right? But the second argument I always make in this is, how do we goose labor force participation rates for populations that we already have here and populations that are not participating in the labor market at very high levels? And folks with disabilities, be it physical or cognitive or emotional, are places where we know the labor force participation rate is extremely low for these populations. So what are the parts where there's some elements where it's like maybe it isn't great for the marketplace? Somebody with severe physical disabilities would have a hard time, on the floor of a casino, for example, right? But somebody with emotional or some element of cognitive ones may be very well suited for a job in coding. And so these are things where, from a broader workforce development perspective, Massachusetts needs to be thinking about how to make work easier in a number of ways. So that could be flexible work arrangements, transportation, workforce development, as we always talk about it. But the three legs of that stool I often talk about are folks with a criminal record, folks with disabilities, and veterans. And these are all populations that they're out there. And the labor force participation rate with folks with disabilities is extremely low. So if you can bring it up 10 percentage points, how many workers do you create? Especially when you talk about tight labor market conditions. Right now, when it seems like we may be heading into a recession, tight labor market conditions is not what people are talking about, but it will be again. We were suffering from tight labor market conditions a year ago. So those are things where, whether it's the commission, but it's also Office of Labor and Workforce Development, it's the employers, and it's thinking about how do we create workers in all the different corners that we can.
Yeah. I appreciate that, and I appreciate the your willingness and the commission's tolerance of me expanding the conversation a little bit. Appreciate the work. I very much appreciate the work. Thank you.
Great, thanks. Before we jump to the next question, I just wanted to call out that in the chat, I added something for Commissioner O'Brien around women in category 3. So there wasn't dramatically different, but there was an elevated amount of management for category 3, but that's on page 31 of the report if you want to explore it more.
Thank you, Dr. Melnick, for doing that. Commissioners, anything further? I like to take 10,000 foot views. Couple things. One is appreciate the legislature for putting this as a requirement, this study, which then allowed us to go in with our friends at UMass and Dr. Volberg to do this study. Want to say that the commission has been dogged on the issues that were raised in the study. Commissioner Skinner and myself were pretty stringent on goal setting and continue to be. The commission does with the Cat 3 operators when we have our quarterly meetings. We do have quarterly meetings with Category 1 and Category 3 licensees where we ask about workforce and supplier diversity every time that we talk. Talking about OSD and the SDO, we are award winners and we get the, we don't rest on our laurels. We are happy to get the awards, but we know that, the sky's the limit when it comes to this issue, that there's always the next frontier. I will say that I've walked downstairs and heard Derek Lennon and his team really talk about how we can increase internally where we're putting our dollars, and that matters, to your point, Dr. Malik. And then I am going to I want to see if John Scully can add something, but I will say that personally, Just for Men helps me from adding to the graying workforce in Massachusetts, so I'm doing my part on that front. John.
Thank you, Chair Maynard. As Chair Maynard has stated, the commission works very diligently. The entire staff has worked really hard on getting our numbers up. We have been recognized by the Supplier Diversity Office. I think we, correct me if I'm wrong, I defer to Dean and Derek, but I think we just, we got 5 awards from them for the hard work that the staff has done in this area. I would say that, Dr. Volberg and Dr. Melnick, the points that they raised in their presentation are things that we are aware of as well. And I just wanted to point out that the commission's always trying to be proactive, and that just recently, I believe it was June 16th, we had a joint event with the Supplier Diversity Office and our licensees, both sports wagering and casino, where we addressed some of these issues, like that you had pointed out that it is tough for folks to get like SDO certified, and what avenues that they can go about as small businesses. So that was part of the point of that event. It was to get all the different stakeholders in one room. I just wanted to note that, we are trying to be proactive about this. We've also gone, as part of our mission to walk the walk, because we require it of our licensees. We've also gone, not only are we trying to show that in our numbers, but we've also gone and gotten software. And I defer to Derek and Dean on anything further. I know I'm speaking a mile a minute, so I'm going to pause there.
Yeah, I think that was a great overview, John, but I think Dean may want to touch on a few things, and I can clean up around the edges. Thank you, John.
No, well, no, I was going to say the same, that John, that was a good summary. Appreciate it, and all the work your team does. I think the lesson on all of this is that you need to take baby steps and make progress in the areas as you can, right? Small businesses need a helping hand. They need technical assistance. We work directly with the SDO. We work directly with the operators, and we as an organization have real dedicated resources to it. But in the end, it's about, from this presentation, my takeaway is, let's go find some marketing companies, right? Some minority-owned, diverse marketing companies that can participate in some of the dollars that are spent by the sports wagering operators, because that was where they're spending all their money, right? So it's like a micro target. But we can do that, and we can train our resources on that, and we can go to the SDO and say, hey, look, we heard this presentation. Let's go find some Massachusetts marketing companies. But we can also make sure our staff, to the extent we have them focused on this, can help companies navigate the SDO and little by little add to the portfolio that the operators use. We did have approximately 100 small Massachusetts companies participate that event. And one of the things I talked to the staff about at the time, and to Tom Mills, our communications person, is let's keep an eye on the work that comes out of those meetings. Let's work with the operators to find the companies that received orders or contracts, follow that along, and then highlight it in ways that we can, whether it's on our own website or our own blog. But spread the word that if you put the time in, and if we can help, there's business on the other end of that rainbow. So that's all I would say. Derek, if you have more to say, go, please do.
No, that's a perfect summary. The one thing that John was talking about is we actually are procuring Supplier IO, which was a software that was brought forward by one of our licensees. We'll be buying that through a diverse vendor on statewide contracts. So we'll capture the diversity spend there, as well as that will help us to find other businesses that may not have an SDO certification, but are operating in Massachusetts, and work with them to get them certified. In the past, we have actually, Beniswa left, and before Beniswa, we had a vendor firm that would actually help the small businesses do the paperwork. So it wasn't on them to do it. We took on the cost of doing that for them. So these are the areas that we agree 100% with UMass Donahue Institute and their research that we can get better. When you look at our numbers, as I point out every time on a quarterly, if we lose one or two vendors, we miss our marks. So we are always trying to diversify our business portfolio and our vendor portfolio. So thank you for the work on this. Thank you for the analysis, and we will continue to try to get better.
Thank you, Chief Lennon, and ED Serpa. Anything else on this matter?
Chair Maynard, if I could just say one thing. This study had some particular issues that made it challenging, and I really appreciate Dr. Melnick, Dr. Volberg, their team, and especially Dr. Andrews for sorting it out and bringing this issue into pretty clear light for us. So thank you for your diligent work to bring it to the commission today.
Thank you, Director Van der Linden. I agree with all my colleagues here, and like I said, better isn't good enough for us at the MGC. We're always striving for perfection, knowing that it's better to strive for that and miss than to never try. Anything else to add, Dr. Volberg, Dr. Melnick?
Nope.
All right. So, with that said, commissioners, I hate to do this, but I need another break, and I wanted to ask, what the time needs to be on the break. Looks like we don't have much on the other side of the break, but if you want to do a lunch, or if we don't want to do a lunch, I'm open to suggestions. Commissioner Skinner?
I could use about 20 minutes to grab lunch as one commissioner.
I'm getting, and Commissioner Hill said the same, Commissioner O'Brien. All right, so let's meet around 1 o'clock. All right.
Thank you.
All right, Connor, I think we can take the screen down. All right, this is a reconvening of the Massachusetts Gaming Commission. It's approximately 1:02 p.m. We're holding this meeting virtually, so we will do a roll call. Good afternoon, Commissioner O'Brien.
Good afternoon, I'm here.
Good afternoon, Commissioner Hill.
Hello, I'm here.
Good afternoon, Commissioner Skinner.
Good afternoon.
And good afternoon, Commissioner Broder.
Still here, Mr. Chairman.
All right, glad we didn't lose anybody. Okay, so we left off on item number 9, and for that, we are going to kick it over to Councilor Stimpak.
Good afternoon, Chair and Commissioners. We're coming back before you today for final promulgation of some changes to 205 CMR 256, which speak to sports wagering advertising, specifically the change which we had brought previously to the Commission for initial promulgation back in March. What would add a requirement for a disclosure in sports wagering marketing or advertising to make it clear what the relationship was between the individual or entity and the sports wagering operator, and essentially to make it clearer to consumers that something was in fact an advertisement. We did receive several comments on this from a couple of our operators and one non-operator entity. We reviewed those with sports wagering. And at this point, we would recommend continuing with the adoption of the original language and not changing it. We believe that the language as written provides broad discretion to sports wagering, and that sports wagering will be empowered to work with the operators for the best path forward while having flexibility with the existing language. But Carrie Teresi is on the call as well to offer her insights from the sports wagering perspective, and we're both here for any questions the Commission may have.
Thank you, Councilor Stimpak. Commissioners? Questions, comments?
My only comment is I agree with what Attorney Stimpak just said and recommended, went through, looked at it with the 2x2s. And I do think that that's the language we have is the appropriate way to go.
Commissioner Broder, thank you, Commissioner O'Brien. Commissioner Broder, yeah, Commissioner Broder.
Briefly, agree with Commissioner O'Brien. Again, just to make clear the goal, to make it very explicit, we are trying to help consumers understand what is advertising and the nature of the advertising. And it really is as simple in most cases as understanding that when Kevin Hart or Eli Manning or whoever the case may be, appears in an ad, that it is understood and communicated to the betting public that these folks are being paid for that endorsement. It happens in a lot of other industries, not nearly as complex as what pharma has to do around their advertising. I think it's a positive step forward to protect the consuming public.
Thank you. Any other comments, commissioners? Were there any comments on this, Councilor Stimpak?
Yes, we did have comments from IC360, from Fanatics, from BetMGM, and from FanDuel. And we did read through all of those, understand the issues that they raised. However, Carrie and I discussed that we believe adopting the language as we initially wrote it would be the best path forward. And then sports wagering would obviously communicate sort of practical on the ground implications of what expectations are with individual operators.
All right.
Happy to move if we're there.
I was going to say, any other discussion? Commissioner Skinner?
Nope, I'm just getting ready.
You're ready. You're ready to discuss. All right.
All right. I move that the commission approve the amended small business impact statement in the draft of 205 CMR 256 included in the commissioner's packet and discussed here today. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize the regulation promulgation process.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0. All right. Thank you for your work on that, Councilor Stempick and Carrie. And with that, we're going to turn it over to the IEB, Director Monahan.
Good afternoon. So today we have a recommendation of a civil administrative penalty for review by the commission, and Zach Mercer is going to be handling that. So I will turn it over to him.
Thank you, Caitlin. Good afternoon, Chair and Commissioners. Today, the IEB is presenting its recommendation that the Commission assess a civil administrative penalty in the amount of $10,000 upon American Wagering, Inc., doing business as Caesars Sportsbook, for a non-compliance event occurring between September 1st, 2023 and April 30th, 2024. The regulation implicated in this violation is 205 CMR 248.044, requiring the use of knowledge-based authentication questions in account establishment and sports wagering accounts. This matter originally arose in the April 30th, 2024 public meeting when the Commission had heard and approved Caesars' request to implement an alternate identity authentication process under 205 CMR 248.044. On that date, following some questions regarding Caesars' process prior to the request, the Commission asked the IEB review the matter for potential noncompliance. The IEB provided an initial briefing to the Commission at the July 11th, 2024 public meeting, at which point the Commission requested additional information. The IEB returned before the Commission at the February 6th, 2025 meeting to present supplemental information, at which point the Commission assigned the matter to the IEB pursuant to 205 CMR 232.011A. The facts of this incident, as the Commission is likely familiar, involved Caesars failing to include those knowledge-based authentication questions in its Know Your Customer or KYC protocol at account establishment for the relevant time period. On June 13th, 2025, the IEB submitted its recommendation to the Commission by email. As outlined in the recommendation, the IEB investigated this matter, had additional communication with Caesars regarding the cause of the incident and remedial measures taken. During the IEB's review, no additional information was uncovered that would materially change the nature of the noncompliance incident as previously presented to the Commission. This was a lengthy review, and Caesars was responsive and communicative throughout the process and agrees with the IEB's recommendation. So based upon the IEB review, communications with the operator, guidance from the Commission, the IEB is recommending that the Commission assess that $10,000 civil assessment upon Caesars. And at this stage, the IEB is requesting the Commission's decision on one of the options under 205 CMR 232.023 A and B, of which the Commission is familiar. One, to adopt the IEB's recommendation as the Commission's final decision, or reject the IEB's recommendation and issue a notice of intent to adopt a separate recommendation following an adjudicatory hearing. And obviously, as always, I'm happy to answer any questions for the Commissioners.
Thank you, Councilor Mercer. Commissioners, what do we want to do? I'm okay with moving forward, as Councilor Mercer mentioned, and adopting this. Commissioner Brogan? Okay.
I'm okay with moving with the civil administrative penalty recommended by IEB.
Same for me.
Same.
All right. I don't think we need a vote on this. I think you got what you needed on that, Councilor.
That is sufficient. Thank you, Chair and Commissioners.
All right. Anything else, Director Monahan?
That's it for today. Thank you very much.
Thank you, and thank you for all the great work that the IEB does on a day-to-day basis. Thank you, Councilor Mercer. I'm using my computer to do the agenda today, so I have to scroll back and forth as I go through the materials. Sorry about that. I believe we're on item number 11, and for that we are going to go to the CFAO, Derek Lennon.
Good afternoon, Mr. Chair and Commissioners. I'm joined by Dean Serpent, Doug O'Donnell, John Scully, and Treasurer O'Brien for, I think, her last time as treasurer. And we're here to review and hopefully vote on staff's recommendation for the MGC's FY26 operating budget. Today, we're recommending a $63.96 million budget, funding 143.7 FTEs and 8 contractors. This will provide regulatory oversight of gaming, sports wagering, racing, player health, and community mitigation fund grants. The materials begin on page 259 of the public meeting packet. Quick overview, just like last time, of our process. We're fully funded from assessments, fees, and taxes on our regulated industries. We begin our budget building process in February. Every division submits a spending request to our office. Those are reviewed by the executive director, then a second time by the commission's treasurer, a third and executive director, then a third time by our licensees, a fourth time as we presented on June 17th to the commission with our projections. Then we put our documents out for public comment, which we did from June 18th through June 27th. We did not receive any public comments. And then finally, today's presentation is so that the commission may make any recommendation for adjustments after they've seen it for the last 2 weeks, or seek clarification on any of the information, and hopefully then vote to approve the FY26 commission's budget. The information in the packet has not changed, other than I included the table that was missing on page 3 of the memo, which I had to pull up my spreadsheet for on the 17th, as well as I included on pages 9 and 10 of the memo, the distributions of the assessments for sports wagering operators, because our May revenue had come in and it is posted now to our website. So we could say this is what has happened from July 1 through May 31. Just as a high level overview, this budget proposal is a 5.98% increase over FY25's currently approved budget. Our FTE count is looking to stay flat at approximately 144 FTEs. At a macro level, and I'll just hit the highlights because we went over this in detail last time. Salaries are growing by 3.5%. This is due to a 3% COLA and projections of 7.5% turnover savings. Fringe benefit costs are decreasing by $964,000 due to an anticipated reduction of approximately 8% in the federally negotiated fringe benefit rate. Our lease is growing due to us being out of a renewal year. Consulting costs are increasing by $678,000 due to potential rebranding initiative, as well as additioning audits in the sports wagering division. GEU collective bargaining increases are going up by about $684,000 or 4.6%. Our research costs are increasing by $202,000, and the cost of the AGO, which we touched on briefly, we had additional budget dollars in there, but about 1.5 million, and that was anticipating the $3 million cap being lifted. However, they're still going to need additional funding sources, so I would recommend leaving that in there until we can talk through the interplay between sports wagering and gaming and where we can help our partners over there. Our budget is funded through fees, assessments, and transfers from the Public Health Trust Fund. Assessments from our sports wagering and gaming operators make up $49.84 million of our $63.96 million budget. The balance of the budget is funded from gaming, racing, and sports wagering fees, as well as a transfer of over $6.6 million from the Public Health Trust Fund. At this point, we're available for any questions, comments, or suggestions, and we hope we get a vote. Thank you.
All right, so thank you, Derek. Thank you, Doug and John, and Treasurer O'Brien. Commissioners, questions? Does Commissioner O'Brien want to do the honors?
Before I do that, just and Paul will find this out shortly, but for those of us who've been treasurer, just to give a shout out to the finance team. It's really a pleasure to serve in that function. They do a tremendous job with the budget. I'm going to miss it. You'll be in good hands next year, but they do a wonderful job. And part of the reason there's not a lot to talk about is because they do such a great job getting it ready and keeping us briefed before we get to the vote. So with that, I am happy to move that the commission approve the proposed FY26 budget as included in the commissioner's packet and discussed here today.
Second.
Thank you, Commissioner Skinner. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0.
Thank you very much.
Thank you, and we look forward to making good use of these dollars to ensure the integrity and utmost responsibility of our mission, which is to regulate the gaming, the horse racing, and the sports wagering industries in the Commonwealth of Massachusetts. All right. I believe that brings us to the end of our meeting. Do we have any commissioner updates? Do we have any other business that we didn't anticipate? Do we have a motion to adjourn?
Move to adjourn.
Second.
Thank you, Commissioner Broder. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0. Everyone have a wonderful 4th of July. Enjoy your time with your families and friends, and hopefully get out to see some fireworks legally and enjoy it.
Yeah. Happy 4th, everybody.
Yeah.